Welcome to another episode of Image Rights by N. Mashinini, the only podcast dedicated to image rights in Africa and around the globe. Welcome to another episode of Image Rights by N. Mashinini. Today we have Mugambi Laibuta, an advocate of the High Court of Kenya, joining us to tell us a bit more about image rights in Kenya. Mugambi is a trained mediator, a legislative counsel and policy analyst, plus a privacy and data protection specialist. He is currently a PhD candidate at the University of Witwatersrand, researching and writing on privacy and data protection in Kenya. He provides consulting and advisory services in policy development, governance, rule of law, constitutionalism, legislative drafting, digital rights, internet and technology law, privacy, as well as data protection. Mugambi also teaches legal writing and legislative drafting at the Kenya School. On privacy and data protection, Mugambi has carried out data protection impact assessments and drafted data protection policies and documentation for regional institutions in East and West Africa. He has carried out similar consultancy assignments for private and public sector clients in the region. He also has drafted a data protection bill and regulations for a state within the Horn of Africa. He trains institutions on their obligations in data governance and works with them to ensure compliance with universal data protection principles. In addition, Mugambi is involved in constitutional review processes in Kenya, South Sudan, Somalia, and Chile. Mugambi, thank you for joining us.
Thank you for having me, Nomalanga.
How are you doing today?
Doing great. The life of a PhD, considering the life of a PhD student, I'm surviving. I'm okay.
I'm actually laughing because I just recently graduated with my PhD, and I'm still sort of coming off the high of the stress of the workload and everything. And it does take a lot out of you, I must say.
Yeah, congratulations on that.
Thank you, and all the best. So your PhD is on privacy and data protection. And this is what caught my attention about your profile, is that you and I are in sort of similar spaces, although we're sort of in distant fields, but related fields. Because as much as I don't necessarily specialize in data protection, my specialty is in image rights, which is why you're on the podcast Image Rights by N. Mashinini. And I know that sometimes image rights are often protected through data protection and privacy laws as well, especially with the murky situation in a number of jurisdictions relating to image rights. And so I firstly wanted to start by taking you into my field of image rights before we get into the data protection aspect of image rights. And the first thing I want to know is, are image rights recognized either directly or indirectly in Kenyan laws? And how does the nature of the Kenyan legal system influence the legal position relating to image rights?
Okay, thank you, Namalanga. So image rights, as you stated, maybe expressly or implied, and in Kenya, actually, the courts haven't really talked about image rights, but as you read from the decisions of the courts, then you are able to analyze and state, yeah, here the courts are protecting image rights. Let me give you an example, one or two decisions. So there's one decision, it's called COM versus Standard Group, and another. So here the newspaper published the photo of this individual, but the person said that he did not provide his consent, and argued in court, in the petition, they argued that this was a violation of their right to privacy. You see, it was an issue to do with their image, but they argued it out as a privacy issue. And what the court decided was that the newspaper, that is Standard Group, required to have written consent of the petitioner before they could publish this person's name and photo in the publication. And because of this, the court awarded damages. So that is one. In another decision, and I'll be talking about quite a number of decisions. There's another one, but this one is on the revenge porn kind of like sphere, but it's also about images. So in this decision, which is Roshanara Ibrahim against Ashley Kenya Limited, so here two individuals shared intimate images, and these images were made public. So here what the court stated that the person who shared these images had an expectation of privacy, and that in as much as the photographs were not obtained in an intrusive manner, the access was limited to the recipient and not to the general public. And because of that, the court awarded damages. Now, in another decision relating to children, now this is relating to minors, it's a case called NWR versus Green Spot. So what happened is that there were images of children that were taken while they were playing football. And then these images were used to promote gambling on the billboards. So the legal guardians of these children went to court and said, you know what? No, there are personality rights of these children, and that the use of children's images, there needs to be consent. One, the fact that they used, of course, using children's images for gambling, that was a problem. But secondly, using the images without consent and without compensation. So the court said that if you're using one's image, you need to seek their consent, and they need to be compensated, and that consent must be expressed. So for now, let me talk about those three decisions that indicate that the court actually have moved towards this, that if you're an individual and somebody uses your images for whatever purpose, and mostly it's a commercial purpose, then you're able to go to court and argue it out under Article 31 that your right to privacy has been infringed. And the court will make that argument. Yes, one's image should only be used for a commercial purpose with express consent. And without that express consent, then there's a violation. And for that reason, one will deservedly be awarded damages to that extent.
It's interesting because what I'm getting from what you're saying is that the jurisprudence on privacy is sort of overshadowing what should be the jurisprudence on image rights. I'm thinking about some of the things that are coming up here, commercial exploitation, in the revenge porn spaces as well. I'm also wondering if it is sustainable to always look to a legitimate expectation in the kind of world we live in. Because one of the things I always think about, I'm thinking about the revenge porn case, that the images were shared between parties. And one of them decided to share it with the public. So I see the violation of privacy in the form of unwanted disclosure there. But what about a situation where I've shared my intimate images with the public, but just not for commercial exploitation, and then someone else chooses to commercially exploit it? Can we still use privacy to protect my interest in those instances? Or are we really now supposed to be developing the image rights jurisprudence to protect such interests? Because in those situations, I don't necessarily see that much of a legitimate expectation, but I do see an intrusion on my personality rights, specifically my image rights, because of the commercial exploitation that takes place.
Well, okay, there's another decision. So this decision, it's not a revenge porn, but it's quite interesting. Maybe it might answer some of this question. So it's called Rukia Idris Bari versus Mada Hotels Limited. And what happened was that the plaintiff was an employee of the respondent, that is Mada Hotels. And well, in that employment, photos were taken, there were photos that were taken in the course of her employment, but then these photos were published in in the Kenya Airways Limited online magazine, which is called Msafiri. So what and this was without the photos that were taken during her employment were purely for employment purposes. They were not motivated to be used for profit, which was an argument that later the publication in this magazine, it is used for employment. And what they said is that there was no consent sought or obtained for the commercial exploitation of her likeness. So that perhaps will answer your question, that if somebody shares intimate images publicly for the fun of it, let's say for the fun of it, but someone else takes those images and uses them for a commercial purpose, then within the Kenyan framework, perhaps a litigant will come to this case and say, you see, these photos were taken, but not for commercial exploitation. Yeah. Therefore, the fact that they've been used for commercial exploitation, then that is a violation of the image rights of these individuals, and they are entitled to relief. So this person was awarded 300,000 Kenya shillings, which is maybe around $2,500 for commercialization of our images without her consent. So I think in the question that you asked, somebody shares the intimate photos and used for a commercial purpose, perhaps the court may be guided by this decision.
It's true. It's true. And I love the fact that you were touching on that kind of a context, because my next question is about the way in which the protection of image rights is trending, even though it's not coming straightforward as image rights. There's clearly a trend in people fighting for the use of their images and so forth. And what I'm seeing is that social media is going to force us into a number of cases where courts have to be decisive about how to deal with image rights. And my question to you then is what regulatory trends are coming forth, specifically in relation to social media and also in the data protection space, that you could see as indirect mechanisms to resolve the violations of image rights? Because I think a lot about how in South Africa we've got new legislation like the Cybercrimes Act, which also brings a new sphere into the protection of image rights, such as also the Protection of Personal Information Act brings a new sphere to the protection of image rights. We're moving away from a purely common law approach. What are the trends in Kenya relating to social media specifically?
I've not seen a decision on social media. However, I came across one, which is a 2022 decision. And maybe this may be a guide, but because it's a Court of Appeal decision, there's no Supreme Court decision on this. So this Court of Appeal decision is Thabiti Sacco against Sharon Nyaga. So what happened was that the appellant, Thabiti Sacco, had used the photograph of the respondent without her consent. And so they took this respondent's photo was taken and was used in a calendar, and this calendar was spread in many branches of the appellant's of the appellant's establishment. But then the plaintiff at the beginning now, who is the respondent in this appeal, she had stated that at no particular point was she asked or did she provide consent for her images to be used for financial benefits by the appellant. And so the court said that the exploitation of her photographs, this is actually a High Court decision. It's the highest that I've not gotten a Court of Appeal decision, but it said that the High Court judge said that to admit to having used the image for a financial reason without deference or without knowledge or consent of the respondent, then that was a violation of the right to privacy. It was a right to privacy argument. I have not come across, perhaps it's there, but it's not reported, where the argument has been under cybercrimes, computer misuse or cybercrime legislation. Because there's been a lot of debate about the constitutionality of the Computer Misuse and Cybercrimes Act, though it's operational now. You find that people are quite, it's really not being used to the level that perhaps it should be. So the arguments still remain. Article 31, allegations on breach of privacy, but perhaps in future it might go towards the cybercrimes angle, but we are not there yet.
Now, I want to ask you about this privacy and data protection issue, specifically relating to the adequacy and efficiency of remedies that we find in data protection and privacy principles. Do you think data protection laws, specifically in Kenya, and the current state that they're in, do you think they are sufficient to protect people's image rights? online in particular?
Um,
I'm putting you on the spot.
Yeah, sounds like a question I should be answering in my PhD thesis. But ideally, I mean, I think you ask a very fundamental question about effective remedies under the Data Protection Act and image rights. So for a start, in terms of general availability of effective remedies, because effective remedies under privacy and data protection, one, the remedies must be by an independent body, they must be available, they must remedy the wrong, they must be easily accessible. So currently, we have the Office of the Data Protection Commissioner. That was, it's around more than 1.5 years old, that office, but it hasn't made any pronouncement about any complaints made. So one of the issues is that the office says that it still doesn't have the funding or the personnel to be able to deal with the complaints that are before it. So it will be a while before we see the efficacy of that. So the remedy now remains, for example, an issue of the image right. It remains a petition perhaps to the High Court on substance of Article 31 on the right to privacy. But in terms of data protection, that office is not operational fully yet. So for that reason, that remedy is really not available. And secondly, there are instances under the Data Protection Act where there are two centers of power. There's the Cabinet Secretary in charge of information, communication and technology that has a role under the Data Protection Act. So those two centers of power, I think moving forward will be a challenge, but of course not dealing with the image rights, I mean, in terms of data protection generally. But looking at the jurisprudence that has been there, especially from the High Court, it shows that the High Court is providing remedies to individuals who claim, though in their mind, I don't think they see it as an image right issue.
Yeah.
They see it as, my image has been used by someone for monetary profit. I need also to be paid by this person who made money out of my image. That's, I think, simply how people look at it.
Yeah. It's sort of similar to the way in which the jurisprudence on image rights developed in South Africa as well. A lot of the claims were mainly about just people bringing in an aggression to dignity, and then it developed to specific subjective right of identity and so forth. But as usual, even in the States, what you will normally see is the celebrities will drive the jurisprudence in this area. And if the celebrities are not coming out with claims, chances are the development will be slow in that jurisdiction. It's just the way it is, that celebrities, especially sports players as well, they are the ones who will normally be leading in bringing such claims. The reason why I was asking you about the efficacy of remedies and so forth is because I know that and a number of African countries, we tend to follow European regulatory approaches. I mean, I hear you talk about your data protection laws and the office that you refer to, which is quite similar to our information regulator, also similar to the officers in the GDPR context. And I tend to ask myself, are we doing our countries any justice by adopting methods that have worked or do work elsewhere because of the sufficiency of capacity and finances to manage such offices? Are we too ambitious as African countries, trying to copy the ways in which other big, top, powerful countries, powerful continents are regulating their own data protection issues? Do you think we're doing this right in Africa?
Yes and no. Yes, to this extent. A lot of countries, I think, let me talk about Kenya. Kenya is a signatory to various international conventions that provide for the right to privacy. The International Covenant on Civil and Political Rights, the Conventions on the Right of the Child, the Conventions of Persons with Disabilities, all these conventions provide for the right to privacy.
Yeah.
Because the right to privacy is really not a new thing within the African continent. if you look at, especially for countries that British colonies, the former British colonies, the independence constitutions had the right to privacy for someone's person, someone's home, someone's property. It was not an individual right to privacy, but it says someone's home, someone's property. There needs to be some privacy. And secondly, these constitutions had provisions that also provided for a very nuanced use of search and seizure processes. That you can't just go and search and seize somebody's property. There needs to be a very specific process to carry out this. So privacy and data protection is nothing new within the African continent. It was there, of course, with the independence constitutions and various acts of parliament coming there. For example, regulations relating to banking, the customer bank confidentiality, for lawyers, advocate-client confidentiality or lawyer-client confidentiality, for doctors and patients, So these principles were there within our legal system. And even if you look at traditionally, in various African cultures, there was some sort of privacy in different contexts. For example, in the community I come from, there was a council of elders, and this council of elders, some of its deliberations were secret. That was privacy to a certain extent. During initiation processes, you'll find either the girls or the boys who are being initiated to whatever level, they were secluded, and matters shared, whatever was shared within that age group was secret just to them. So if you make an interrogation of also our traditional system, there are, as much as people say we were communal, but there are instances where secrecy was there, even intimacy between spouses. Whatever the information shared between spouses, that is privacy. So what now comes in is the issue of information privacy and information security, which perhaps was not really within our culture. Because when you look at it, for example, the GDPR, before then the GDPR came into being, they had the Convention 108, automatic processing of personal data, then the Directive on 95/96 that now culminated into the GDPR. So there that tradition of information privacy, which perhaps we really didn't have. We had that general right to privacy. So then this tradition now where we are trying to implant, we are trying to just cut and paste and put it into our systems without putting in place the correct structures. For example, in the EU, the political goodwill was already there.
Yes.
The political systems had already agreed in all of Europe that we are doing this.
Yeah.
Look at, for example, POPIA. POPIA was enacted in 2013, came into operation in 2021.
Yeah.
The Kenya Data Protection Act was debated for more than 10 years. It was only put in place because government wanted to put in place a digital ID system. Mm. So that lack of political will and the lack of all systems and resources going towards this then puts us at a challenging point. But the data protection principles are there in either the legal profession, the medical profession, in the banking industry. So those are the challenges that we are facing, but I think at the top is the lack of political goodwill, the lack of having regulators that are truly independent and that have the resources to carry out this, because the right to privacy is there. And the data protection derives itself, its principles, its functions from the right to privacy.
So you touch on political will, which brings me to my next question. I want to know from you what regulatory developments and improvements at all the branches of law, would you like to see coming out of Kenyan regulators in the space of data protection, particularly in the broader sense of your study, but also specifically in the context of image rights and what we're seeing online with the way in which artificial intelligence is also bringing in a new mix of image rights violations? Or what would you like to see from the regulators?
Also, there's this argument, is image rights. So I had a conversation with a colleague on is image rights an IP thing or is it a privacy thing?
Yeah.
And for me, I was like, it's privacy, because I mean, this is what the courts have been talking about. But there's also that aspect: to what extent does it lend to us? Because according to this IP rights expert, is that we really don't have image rights, in that we don't have it's not expressly stated in the law that there are image rights. But when you look at our jurisprudence, you're able to see that there are image rights are there. So I think perhaps that needs to be articulated. I don't know whether it's best, whether it stays as jurisprudential progress, or it needs to be stated in an act of parliament. I'm not sure. But I think within the African continent, I think what we need, for example, the convention, the African Charter does not provide for right to privacy. And it's been argued, because of that, then why should we think about these issues? But then we have the Convention on Cybersecurity and Protection of Personal Data. We have the model law, the data protection model law, the SADC region. We have the Act, the Protection of Personal Data of ECOWAS. So in terms of image rights, I think there needs to be perhaps a concerted effort to, because especially as you said, in the age of social media and the technology, this is really becoming a problem. And also where you have deep fakes, which also cause a lot of trouble. Then the question is, how do you deal with this through a regulatory framework? And also the fact that technology is evolving from day to day. Today you might regulate these deepfakes. Tomorrow there's another technology that it makes deepfakes look like a 15th century thing. So essentially I'm saying, I don't know what the solution is, but I think critically is the court being able to articulate and develop this thing. And it looks like it makes more sense from a privacy angle, especially from what the courts have been stated, because then it becomes a fundamental right and freedom issue. Whether data commissioner, Office of the Data Protection Commissioner will deal with some of these issues is yet to be seen. Because I think, images are personal data, and because they're personal data, if you are to use somebody's image for a commercial purpose, you must also take into consideration their data subject rights. You must take into consideration data protection principles. So if these data protection principles are not taken into consideration, and the commercial use of personal data, then I believe the Office of the Data Protection Commissioner in the coming days should be able to issue administrative sanctions and penalty notices for people who are using individuals' images without following the provisions set out in the Data Protection Act and the regulations.
That's quite an interesting point to make. I wanted to just pick up on what you said, that there's no outright recognition of image rights. And it's something that was the biggest point of my doctoral thesis, although there's other primary issues that I deal with there. But one of the big deals about my doctoral thesis is this question that I was investigating, that are image rights even recognized? Because I investigated 4 different jurisdictions, and my findings were that it's not all jurisdictions that recognize image rights. And in other jurisdictions, there's a clear refusal to recognize image rights because the approach of the courts is, well, the privacy principles are sufficient. The privacy principles can help us to protect these interests, which is becoming quite clear to me in the context of social media that the privacy principles are not going to make it anymore. And what's funny is that after finishing the thesis last year, in 2022, this year, a court judgment comes out confirming exactly that in South Africa, because there was a case where this guy wanted to enforce his privacy rights for images that were posted about him. Yet the images and the content that was posted about him was taken from his own social media pages. And the court said you had no legitimate expectation of privacy. I looked at that and thought, had it been an image rights issue, the legitimate expectation of privacy question wouldn't even come up. And so it wouldn't bar the plaintiff from succeeding with a claim. But what we're going to see more and more with the social media issues is this legitimate expectation blocking claims? Because people post their stuff freely on social media without considering that maybe I am letting go of some level of privacy by posting my stuff on social media. But yeah, that's the whole reason why I have this podcast, to raise awareness.
But then again, even if I post something on social media, I may not have that full legitimate expectation of privacy, but then I have an expectation that my image will not be used for purposes that it was not intended to. For example, I shouldn't find my image on a billboard advertising this or that product, because that was not my expectation when I'm posting my image, my photo on social media. So this goes now to the issue of the Data Protection Act that would say, fine, what was the purpose to which you posted this information? Say for my personal reason, for enjoyment, whatever. But I did not post this for it to be exploited for a commercial purpose. Of course, you'll find the terms and conditions by Facebook, by Instagram, etc. They may say they may use your image. But let's say something like a maize flour company uses my image having a meal, and put it on a billboard. No, that would not be legitimate expectation. So I think the court needs to find that balance and ask further questions.
It's interesting you raise this, because every single time in the traditional context of advertising and all of that, it's easy to rule on commercial gain. But in the context of this case, we're dealing with someone who used someone's image and location in order to raise a matter of opinion on a social media platform in the name of wildlife conservation. Now, the problem I have with this judgment is that in the same way that you raise the questions about commercial exploitation on billboards and advertisements and whatnot, the court didn't engage with what is commercial exploitation. It seems that the moment you post someone's details on social media, you are assumed to be engaging in public comment, public fair comment. And I think that we need to scrutinize what is commercial gain, which is what I also do in my thesis. I scrutinize the question of, in today's world, commercial gain, it doesn't look like what it used to look like traditionally. And what I would see there in that case was the conservationist was garnering support for his page using someone else's image. But the court didn't see it that way. It was casted in a free speech context. And that in itself is problematic, in my view. These are the kinds of questions I'm grappling with about how social media is creating this blurry position where we're not clear about what is commercial. We're also not clear about what is celebrity and what is ordinary, who are public figures, who are not public figures anymore. And that is challenging our protection of image rights, which is why I look at countries, for example, like Kenya, where image rights are not even recognized. And I ask myself, if we haven't even started to recognize image rights, will we be able to catch up with the new advanced questions that I'm grappling with now? It's quite an interesting pursuit that I'm undertaking.
Yeah, because I think that question that you raise, is there really public interest for us to know? I mean, an influencer is an influencer, a public person. If they have 100,000, 50,000 followers on Instagram, Twitter.
And another thing the court doesn't grapple with in this particular judgment that I'm talking about, it's a case, it's Smuts versus Buddha. And another question they don't grapple with is the question of what about whether a person's profile is a public or a private profile, because people have different types of profiles these days. Others will have a creator profile, which is very public, and others will have a private profile, which is clearly marked that I'm not expecting everybody to know my business. The court didn't grapple with those questions. There seems to be just a blanket decision of, well, there's no legitimate expectation because you had initially published your stuff. And I think we need to grapple with the deeper questions. here.
There's also, I mean, there was a decision in the US recently. I can't remember the name. I don't know whether it was by FTC. It might be by the FTC, the Federal Trade Commission, or a court there. And the issue was whether a data broker who scrapes information from online platforms is infringing on legitimate expectation of individuals. And the court, either the court or FTC said, no. These are public platforms. If this person is scraping information, people's names, images, emails, numbers, and they're in a public platform, there's no infringement on anybody's expectation. And I found that weird. But then a few weeks ago, the Information Commissioner Office of the UK made a decision on a similar, on almost a similar. So this Clearview, you've heard of Clearview, is this company that goes on and scrapes images of people. So it has billions and billions of images from across the world, and it uses these through AI to help, especially law enforcement officers, to be able for ease of facial recognition. And the regulator, the Information Commissioner Office of the UK, said, no. This is an infringement of, one, the privacy rights of people within the UK, and secondly, it goes against the data protection, the privacy regulation, the data protection regulations of the UK. And then it stated that Clearview needs to delete all information that it has about residents, people within the UK. But Clearview said, ICO, you have no jurisdiction over us. We can scrape the internet as much as we wish, and that's and that's where we are. So even when you look around the world, there are these troubling kind of decisions or situations that you don't know. Now look at it. Clearview scrapes our images from Kenya. Do we even have a regulator who can take Clearview to court? Leave alone the ICO of the UK.
Yeah, and this is why I was asking, is it okay for us to adopt these offices, systems and structures that we can't even sustain in Africa? And I worry that we're heading in a direction where, again, we're trying to copy paste, and we're not sure if this is really suitable for us. But we have yet to see. We have yet to see how it will unfold. But thank you for joining me today. And I think this is a moment where I will ask you to just tell us a bit about your podcast.
Yeah. So I have a podcast, which is Ole Law Podcast, OLE Law Podcast. I haven't created my own podcast episode since I think August last year, but I've done 2 episodes with colleagues. I think the focus on my thesis, PhD thesis, has really taken a toll on me. But what I do on my platform is I discuss different issues relating to privacy, data protection, cybersecurity. I've also discussed Kenya's constitutional state in 1 or 2 articles. But apart from my podcast, I think my blog, which is laibuta.com, laibuta.com, is more updated, where I discuss issues of data protection in Kenya, analyzing the new regulations, talking about data brokers, which we've just mentioned. So yeah, and I welcome individuals to go there and learn more about Kenya's data privacy space.
Thank you very much. And I would encourage people to listen to your podcast and read your blog, because your podcast is actually how I stumbled upon you. And from there, I started to follow your work, and I thought I should actually interview you. And in future, once this doctorate is in the bag, we can even collaborate.
Yeah, and thank you for listening.
Yes. Thank you very much for coming today. And yeah. Remember to control your image rights.